Good evening, ladies and gentlemen. First, we have Rica Sacro for the topic admissibility of evidence. Ms. Rica, you can now turn on your microphone, please. Thank you.
Good evening, classmates. For the admissibility of evidence, Rule 128, Section C states that evidence is admissible when it is relevant to the issue and is not excluded by the law or these rules. One example is in Waterous Drug Corporation versus National Labor Relations Commission, wherein hearsay evidence carries no probative value. Hearsay evidence is, although relevant, but based on evidence, it is not admissible because it is based on personal knowledge, and the testimony hearsay is a type of evidence which is excluded by the rules, and thus it cannot be offered as evidence since it is relevant but it is not competent.
Okay, thank you. Next, we have Sir Alpas for the relevance of evidence and collateral matters.
For relevance of evidence and collateral matters. Relevancy of evidence, in this case, evidence must have such relation to the fact in issues to induce belief in existence or non-existence evidence. Under the law, relevant evidence defined as admissibility of evidence refers to the question of whether or not the evidence is to be considered at all. That is the relevance of business. Second is collateral matters. Under the law, the general rule is that evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. In the case of Toledo, People versus Toledo, the competent evidence was discussed as a part of the decision of the Supreme Court. So in the case of People versus Toledo, the issue of the case is that whether or not the hearsay is admissible as evidence. So in this case, as a general rule, hearsay is inadmissible, but in this case, it has the hearsay evidence was admitted as evidence. So the affidavit of the appellant is considered hearsay because the one who made it was not present under the court to testify on his written statement. But regarding the supporting question as to the exhibit is admissible as evidence, the reason being that it is one of the accepted exception of the hearsay rule. So this is called the declaration against interest, or under the explanation of under the book of Agpalo, it is called the dead man statute. So in this case, the hearsay evidence is considered as evidence. The next case is the Gonzalez versus CA. So in this case, it's all about the credibility of the witness regarding the credibility as a witness under the naturalization. Now, this case is all about the probate of a will wherein the witness was a naturalized citizen. So in this case, the credibility of the witness was questioned and was opposed, but the Supreme Court ruled that under the Civil Code, the qualification for the witness to the execution of will has the qualification are: first is any person of sound mind and of good and of the age of 18 or more, and must be able to read and write, and must not be dumb of deaf. So in this case, it has not mentioned of whether it is naturalized or not. So that's why the Supreme Court has ruled in favor of the appellant. In People versus Rica, it discussed the burden of proof and the burden of evidence. So in People versus Dereco, the case discussed about the issue of the case is whether or not the accused is guilty of rape, despite of the inconsistency and credibility of the testimony. So in this case, it is actually a rape case where the defendant had a different statement. So at the first, during the investigation and after the hearing, it was found out that the statement of the defendant has different different minor details than the first one. So, in this case, the Supreme Court ruled that as long as the testimony of the witness is coherent and intrinsically believable as a whole, discrepancies of minor details and collateral matters do not affect the veracity or detract from the essential credibility of the witnesses. So that's all.
Okay, sir, thank you so much. For the next topic, I was assigned to tackle the presumption. So, let me first define what is presumption. Presumption is merely an assumption of fact that the law requires to be made based on another fact or group of facts. It is an inference as to the existence of a fact or group of facts. But it arises from its usual connection with another fact or a conjecture based on past experience as to what the ordinary human affairs state. So a presumption has the effect of shifting the burden of proof to the party who would be disadvantaged by a finding of the presumed fact. There are two classes of presumption: presumption juris or presumption of law, and presumption hominis or presumption of fact. Presumption of law, it is an inference as to the existence of a fact not actually known, or it arises from its usual connection with another which is known. Presumption of fact, it is a deduction which reason draws from facts proved without an express direction to the effect. There are two kinds of legal presumption. First, the conclusive and the disputable. So conclusive, it always holds as a true and cannot be overcome by evidence to the contrary. The disputable, it holds true only as long as they are not overcome by competent evidence to the contrary. Liberal construction of the rules of evidence was discussed in Section 6, Rule 1 of the 1997 Rules of Civil Procedure. So let me read Section 6. These rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. So, if evidence appears to be doubtful, relevancy, incompetent, and admissibility, the safer policy is to be liberal and not project them on doubtful or technical grounds, but admit them unless plainly irrelevant, immaterial, or incompetent. Quantum of evidence is the weight of evidence, which balance or the preponderance of evidence, the inclination of the greater amount of credible evidence offered in a trial to support one side of the issue rather than the other. Sufficiency of evidence. Evidence submitted may have its own probative value, but in the appreciation thereof, proper degrees are considered by the court. So proof beyond reasonable doubt was also in Section 2, Rule 133 of the 2019 amendments to the revised rules on evidence. It states that in a criminal case, the accused is entitled to an acquittal unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such degree of proof, excluding possibility of error, producing absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Preponderance of evidence, it is the weight, credit, and value of the aggregate evidence on either side, and it's usually considered to be synonymous with the term greater weight of the evidence or greater weight of the credible evidence. So that's the summation of my topic. For the next topic, we have Sir Daguplo. Sir, please unmute. Thank you.
Good evening, everyone. I will be talking about judicial notice as assigned to me. So, judicial notice is limited to facts evidenced by public records and facts of general notoriety. So as discussed, as in the case of prosecutors versus more of Rosales, what was that? In the case of Latte versus Choa, it says that the power to take judicial notice is to be exercised by the courts with caution. Care must be taken that the requisite notoriety exists and every reasonable doubt on the subject should be promptly resolved in the negative. Consequently, in the case stated, it cited sections 1 and 2, Rule 129 of the Rules of Court, which expressly provide the provisions for judicial notice when mandatory and judicial notice when discretionary.
So for now, let's proceed to the next topic, which will be discussed by Ma'am Myrtel Magallanes. Ma'am, please unmute.
Good evening. My topic is about judicial admission. Judicial admission in the Rule 1, Section 4, Rule 129 says that an admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not in fact made. So, the requisite of a valid judicial admission is it must be definite, certain, and unequivocal. Effect of the judicial admission is in the case of Gonzales versus Saldana and Saldana versus spouses ni Yamatali, the court's ruling, this is the case wherein the petitioner told spouses ni Yamatali or the petitioner has issued whether or not the Honorable Court of Appeals erred in applying the rules of judicial admission. So, the issues to be resolved are whether the statement of the petitioners in his answer, the spouse's answers, could be considered as judicial admission. So, statements in the answer constitute judicial admissions which bind the petitioner. So, that is answer is part of the proceedings, but it is the judicial admission is an admission, verbal or written. So we already established that one. So a party who judicially admits a fact cannot later challenge the fact as judicial admissions are a waiver of proof. So petitioner argues that the allegation in her answer are not admissions but are actually defenses to show that the petitioner failed to approve that the admission was made through palpable mistake and or that no such admission was made. So how judicial commission admission be contradicted? It allows one to contradict an admission by denying that he made such an admission and that he can show a proof that there is a palpable mistake.
Thank you so much, Ma'am Myrtel. So for the next topic, we have judicial notice of foreign laws. Ms. Susuban, please unmute.
So the cases that were assigned to me basically talks about judicial notice of foreign laws and judicial notice on city or municipal ordinance. So requirements, there are requirements for the court to take judicial notice of foreign laws. First is when the issue involved is one of fact and not of law. Second, the foreign law must be proved like any other fact. So there are certain exceptions to this. First is when the court has actual knowledge of the foreign law and when the court has already ruled upon in a case involving the said foreign law. So like any other facts, the foreign law must be alleged and proved because as said by Sir Daguplo, the power of judicial notice should be exercised with caution. That's it.
Thank you so much, Ms. Susuban. Are there any concerns? Please raise or react something if okay.
None so far.
For the last part, Everybody, can we turn on our camera or our video so that we can have a pictorial? Okay, 1, 2, 3. Okay, see you on Saturday, and please be active on our group chat so that we can accommodate your concerns and suggestions. Thank you and have a good night.